Welcome, welcome, welcome. Good morning to those of you on the West Coast. Good afternoon to those of you on the East Coast, and hello to everyone else in between. My name is Dan Balkaran, and I am going to be your employment lawyer today for the next 30 minutes. I work for the law firm of Samfiru, Tumarkin. As always, just a little bit of housekeeping before we get started. You can see what we're all about at employmentlawyer.ca. You can contact us at help@employmentlawyer.ca. And you can call us at 1-855-821-5900. So while we're waiting for questions to come in, the last few months where we've done these sessions, 99% of the questions have been about vaccine mandates in the workplace and vaccine mandates from the government and the impact of those on your employment rights and your legal position. And so before we get started, I'll just do a quick primer to remind everyone what these are. There is a difference between the word mandate sort of gets thrown around a lot and confuses the topic a little bit. So I'm just going to draw a distinction between those, with respect to employers and the government. So your only legal right in the event of termination is severance. What a government mandate does is it extinguishes that right to severance. If an employer, absent a mandate, terminates your employment, absent a government mandate, terminates your employment for failing to get a vaccine, depending on what's in your employment contract and various other factors, you very likely have a right to severance. And because it's very complicated right now in terms of who is covered by a mandate and who's not, and does your specific fact pattern entitle you to severance? How should you structure your legal position? It's incredibly complicated right now. I think anyone who's in that position should absolutely talk to an employment lawyer. You can call us again, 1-855-821-5900. Okay, so we still don't have any questions yet. So I'm gonna talk a little bit more about vaccines. One sec. Making sure we don't have any technical difficulties here while we're waiting for your questions to roll in. Okay. So I'm going to talk a little bit more about vaccines, which is again the topic du jour. So as I was saying, your only legal right in the event of your termination is severance. Okay, and what government mandates do is they extinguish that right. So, for example, but those mandates have to be properly papered, or at least in my opinion, they have to be properly papered. So there's a difference, to me anyway, between the government as the maker of rules and laws, and government as employer, even though the government does both things. So, for example, in British Columbia, late last week, I believe, British Columbia government, the provincial government, issued an order in council saying that all public servants have to be vaccinated in order to continue working in their positions. But this was released through an order in council, as opposed to, we'd seen sort of ad hoc previously, different departments saying, or ministries saying, well, everyone in our department or in our ministry should get vaccinated. At least I've seen that in different places across the country. And so, a minister saying everyone in my ministry should be vaccinated is nothing. It's a decree. It doesn't have any force and effect at law. However, the British Columbia Order in Council does mean that all government employees, I'm drawing a distinction between public servants as defined in the Public Service Act, I believe that's what it's called. So anyone who works for the government as opposed to a crown corporation, whether or not employees of a crown corporation like ICBC or BC Hydro are covered, is by this new mandate, is sort of a case-by-case analysis, which again, you'll have to talk to a lawyer about. And you can reach us at help@employmentlawyer.ca and 1-855-821-5900. Okay, so nurse fired while on medical leave do I qualify for EI? This is from Jackie. It has been pending for weeks. Jackie, you haven't told me why you were fired. You fired for not getting a vaccine. If you are, there are. It depends on where you are as well, but certainly there in British Columbia, which is where I'm called. In British Columbia, where I'm called, there are provincial health orders applying to all hospital workers, medical staff, anyone who's in the healthcare profession, requiring them to get a vaccine. And so, in that situation, your right to severance would, and if you're unionized, I'd encourage you to talk to your union rep, because there's only a lot of your rights would flow from your collective bargaining agreement, but your severance rights would be extinguished. But the EI question is a separate question. So EI is a federally run program with federal jurisdiction, or under federal jurisdiction, and the Trudeau government announced a little while ago that it was changing the way that they at front line, the way that they're paying out or assessing EI claims for people who refuse to get vaccinated. And they've said that a refusal to get vaccinated is tantamount to just cause, and therefore your employees who are refusing, who got terminated or got fired because they refused to get a vaccine, therefore also don't qualify for EI. Now there are reconsideration and then eventually appeal rights. This is a roundabout way to answer your question, but the change in how EI is assessed, at least as far as vaccinated, the unvaccinated is concerned, that's a sort of a policy directive. It doesn't have the binding force and effect of legislation. And so if you appealed it far enough, there's a good chance that you would be successful. But the purpose of EI is to tide you over, immediately when you're faced with a catastrophe of losing your job and you need to put food on your plate and pay rent and that kind of thing. So if you have to wait 6 months or a year for it, that doesn't really help you. So it depends, it depends, Jackie, entirely on why it was you were terminated. If you were terminated for not getting the vaccine, it's entirely likely that your EI policy is going to be denied. Oh, there, Jackie clarified, no vaccine. Yeah, I think you're probably going to be out of luck when it comes to the vaccine, Jackie. And at least as far as immediate concerns, you can apply for a reconsideration, and then you can appeal it. But it's a long process that takes you down the road. Okay, Ada asks, I work in IT in a hospital in Ontario. I work mostly from home since the start of the pandemic. I'm non-union. Hospitals made a mandatory vaccine policy. No exceptions. It will be put on unpaid leave on January 13th and just terminated for just cause on January 27th. What are the odds of fighting for severance and damages? Only worked there for 5 years, but she's 60 years old. Well, so I'm not, as I said, I'm called in British Columbia, not Ontario, so I don't know what the provincial government mandates are. And government mandates, if you're joining us late, they essentially extinguish your right to severance. In British Columbia, we have one that covers the vast majority of healthcare workers. There's an argument to be made that if you're not in a health providing position, like if you're administrative and you work from home, maybe you could get out from underneath that, but I think there'll be a tough argument. I don't know if you have a similar such mandate in Ontario. If you do, you have zero chance to severance, essentially. If you don't, then you, hospitals are tough, right? Because it's a situation of vulnerability. Generally, I will say if you refuse to get a vaccine, but you've been doing your job for a year and a half, without getting the vaccine, how can it suddenly be just cause for you not to get a vaccine once the employer changes its policy? Depending on what's in your employment contract and whether or not your employment contract talks about, anything to do with vaccine provisions or the right to change policies. Ada, I would strongly suggest that you speak to, because your matter is very complicated and location specific and fact specific. call us 1-855-821-5900. We have many lawyers in Ontario that can be of assistance to you. Shane asks, is it legal to fill out a record of employment stating that an employee has quit when they are on medical leave? I didn't quit. I was let go for non-compliance. Shane, this happens all the time. So generally what you want in this situation is what turns on for you for the ROE, for the record of employment, is that you won't be able to get EI. So you only get EI if you're terminated without cause. If you quit, you get 0 EI, or if you were terminated for just cause, you get 0 EI. So that's going to be that's going to matter for you. You can talk to Service Canada and you can tell them that, in fact, you didn't quit, that you were on medical leave, and you have proof of your medical leave, like a doctor's note and so forth. They'll probably start issuing EI if you want, unless this has to do with refusing it. Your termination had to do with refusing to get vaccinated. And then, you also, an employer fraudulently, I shouldn't say fraudulently, but deliberately in error will say, fills out an ROE to your harm, that can act like sort of like a force multiplier in your severance claim. So if you do have a severance claim, that fact will be of great assistance to you. So again, I encourage you to speak to a lawyer. I don't know what jurisdiction you are in, but speak to an employment lawyer. For those of you just tuning in, I work for the firm Samfiru, Tumarkin. You can see that in the bottom. We have offices in different places in Ontario, such as Toronto and Ottawa, and also in British Columbia and in Alberta. So you definitely want to give us a call or give an employment lawyer a call for sure. JC asks, in BC, when accepting a new job, and the job description mentions something like "and other duties" or miscellaneous tasks, to what extent can an employer add additional tasks other than listed? Wow, this is not a vaccine question. I didn't expect to get one of these today. Okay, so I think miscellaneous tasks and other duties, as you've labeled them, or as that are in your job description. Well, first of all, nothing really turns on a job description. Second of all, I think these are redundant. I think that the employment relationship is one of master and servant. You have certain rights that are protected, either in legislation like the Human Rights Code or in the common law, but beyond that, your employer can ask you to do whatever it is reasonable for it to ask you to do within the four corners of your job, right? So if you are, you're talking about other duties and miscellaneous tasks. So let's just say, you are a CTO, you're an executive at a tech company, and they say, well, now you've got to start cleaning the toilets like a janitor. Is that something that is part of your duty set? Probably not. And if are they going to fire you for disobeying them? Probably. But then you have a right to severance, right? Your only legal right in the event of your termination is severance, and that's contingent upon what's in your employment contract. And so, if you as the CTO, they say to you, now you've got to clean toilets, and you refuse, under miscellaneous tasks or other duties, if you refuse, they might fire you, but they're not going to be able to fire you for just cause in that situation. Just cause is just, it's simply a way of an employer being able to avoid its severance obligations to you. Okay. And it's a bad outcome for society if you're thrown up the street with no money and no job. And so, the law wants you to get severance, but there are certain situations where the employer is legally justified in not providing you severance. So an example of that would be, there are two broad ways. There are actually three, but two broad ways to get there. One would be a single act that is so egregious that that the employer is justified in no longer continuing the employment relationship. So that would be like going to work intoxicated, theft, fraud, punching your boss in the face, that kind of thing. The other way, the probably the more common way, is failing to meet performance expectations, a series of failing to meet performance expectations over time that you provided clear warning of and an opportunity to correct. So that's your classic 3 written warnings and you're out. The third way to get there is just, if you're a bad employee all around and you've made a bunch of different infractions, you're late all the time, you got disciplined for being late, you were absent, you got in fights with your coworkers, you were insubordinate. At some point, they're just going to say, well, there's a cumulative amount of problems here. We can terminate you without providing you severance. But those are, rarer. And so in your case, in your question, they would be terminating you for a single act. And, it depends on how far away. And I guess this is where you mentioned job description and why that matters. It depends how far away from your core duty set what they're asking you to do is. So, but like if it's a question, JC, and I don't mean to belabor this question too much, but if it's just a question of degree, like if you are bagging groceries at a grocery store and now they want you to, sweep up the produce department, I don't, I wouldn't fight too hard on that one unless you're prepared to lose your job. Okay. Okay. Jackie again, I got 1 week severance for every year worked in BC. Is that very low or average? Well, so Jackie, if you have, this is an interesting question too, or a good question too. I'm talking about severance, and I say over and over again that severance is your only legal right in the event of your termination. Okay, but there's statutory floors that you get, okay, and it's every province has one, and those are in the Employment Standards Act. Now, they're generally 1 week per year. It's a little bit different than that, but I'm generalizing. 1 week of severance per year of service to a maximum of 8 weeks. That's what's your minimum. You can't get less than that. Sounds like that's what they offered you. However, if you're entitled to what's called common law severance, and you certainly would want to talk to a lawyer to find out if you are entitled to it, and that depends largely what's in your employment contract. That's much closer to what, I mean, it's not exact, but it's pursuant to an assessment and a formula, but it's much closer to 1 month per year of service. It's a 4 times multiple. So it's certainly if you haven't signed a release yet for the money you got, and you got more. If you got more than the minimums, 1 week per year of severance, year of service, and you haven't signed a release for it, you should definitely talk to a lawyer. Okay, and just a reminder on that note, you can reach us at help@employmentlawyer.ca, and you can call us at 1-855-821-5900. Okay, Sunny asks, I have been employed with the same company for 15 years. The company was acquired a few years ago. Recently, they have sent a new employment contract with a signing bonus, as well as offering a 10%, I'm going to say raise, but your question sort of trailed off. 10% salary increase. I'd like to mention that no salary increase was given to 3 years. There's a clause in this new contract which states that I will waive my rights to any common law entitlements. Do I have a right to decline? If so, what happens if I refuse to sign the new employment contract? This is a great question, Sonny. So Sonny, if you don't say if you have ever signed an employment contract. You're now faced with a choice. The reason why your employer, most likely, the reason why your employer is saying, hey, sign this contract and we'll give you a big raise and we'll give you a signing bonus for it is because you've been there for 15 years. You're a little bit of a ticking time bomb for them. And what I mean by that is you're probably working under no contract or a contract that does not limit you to the Employment Standards Act minimums. That means if they fire you at any point in time, you're entitled to a lot of severance because you've been there for so long. Common law severance is if you have no employment contract, you automatically get it. And then it's an assessment of your age, your length of service, the nature of your employment, i.e. your position, and your availability of similar employment. So, you're a 15-year employee and you're making $100,000 a year, you're talking about 16, 17, depending on your age, a best day of 17 months of severance calculated $100,000 a year. That's a very, very bad day for your employee. Let's just say 12 years. So, be $100,000 liability. That's a very bad day for your employer. Now, if there are a whole bunch of employees in that same, similar position to you, you could be talking about a potential liability in terms of severance to its employees of millions of dollars. And so, Sonny, you 100% more than anybody else that I've spoken to today. You need to talk to a lawyer. You need to talk to a lawyer immediately before you sign that contract. You need to have that contract assessed. You need to understand what it is you're giving up, right? Like you are getting what was it, a 10% raise and a signing bonus that we don't know the amount of, what are you giving up in exchange? It might be a lot. It might be not just a huge potential severance payday, but it's also job security, right? Like if your employer knows that to fire you, it's going to have to pay out $150,000, it's not going to fire you. Okay. And as people get older, that starts to matter, as even though they're not permitted to under the human rights legislation, employees, once they hit the back half of their 50s, they have medical issues, they're away a lot, they're perhaps not as productive, and employers look for ways to get rid of them. So, the cynical side of me, the cynical lawyer side of me looks at this and says, well, they're not only they're trying to protect you, but they're giving themselves, by making you sign this contract, they're giving themselves the option of getting rid of you sooner rather than later in an affordable way. So, Sonny, you need to talk to an employment lawyer. I don't know what jurisdiction you're in, but call us right away, 1-855-821-5900. Pay for an hour of a lawyer's time. Have your contract, this prospective contract, assessed. Don't sign it. My advice to you is not to sign it until such time as you've talked to a lawyer. Okay. Sylvie asks, no choice for anyone. Get a vaccine or lose your job. That's not a choice. And then she says severance. Wow. Yeah, I mean, listen, your only legal right in the event of your termination is severance. Sylvie's not wrong. That's a paltry it's paltry compensation. I mean, it can be a lot. The Sunny person I was just talking to, he might have a huge payday. If he's making, a significant amount of money, he might have a six-figure payday coming to him potentially. But for most of you, losing your job is a financial catastrophe. You don't want to lose your job, especially if you like it there and you have several years in the tank there. It's the only thing you've got in terms of your legal rights in the event of your termination, but it is a small comfort against, I shouldn't say a small comfort, but for a lot of you, you'd much rather keep your job. And so if you're being, if your employer is saying you must get a vaccine, and you've decided that, losing your job is a non-starter. It's a financial catastrophe for you. It's a life catastrophe. And for a lot of you, it really is. Like if you're, I always use this example, but if you're 53 years old with no university education, making $85,000 a year, you can't lose that job because you're going to come back into the workforce, making half of that. Okay. So you've got to figure out some sort of accommodation, and for bigger employers, and obviously if there's a government mandate, there's nothing you can do about that. You've either got to get the vaccine or you're going to lose your job, and you're going to lose your right to severance and EI as well. But if it's a smaller employer, and you've been there for a while, maybe you say to the employer, listen, I've been working remotely for a year, if that's been the case. I love it here. I understand you got to protect the health and safety of the population. I can't get the vaccine for X, Y, and Z reasons. Can we reach some sort of accommodation? Like, can I work remotely? Can I do PP? But you're only appealing to the goodwill of the employer vis-a-vis your relationship, and I guess your productivity. So, you got to keep it nice. A lot of people that I talk to about the vaccines are very upset about, as Sylvie seems to be, very upset about the fact that about employers and the government infringing upon what they see as their right to make their own medical decisions. But and I understand that, but you can't let your anger make strategic decisions for you about your life. You need to be calm about what your choices are. You need to think about it dispassionately. You need to assess what's important for you in your life, and then you need to figure out your strategy and priorities in order, and then execute your strategy in order to get the best outcome for you. Because for a lot of you, you can't afford to lose your jobs, and if there's any way you can keep your job, then you do that. For some of you, who definitely are not going to who will refuse to get the vaccine, maybe if you can work it out with your employee that you can be in some sort of, permanent unpaid leave that preserves your right to return to your job, if and when all this blows over, right? Because the thing about COVID, if anyone tells you they know how this is going to go, they're wrong. They're lying to you, because we don't know. Things change so rapidly in terms of new variants, and then government reactions to the variants and society reaction to them. So, right now, right now there's a paradigm in place that says, an emerging paradigm where to be vaccinated or to continue employment, you have to be vaccinated. But that might not be the case in a year from now. We just don't know what's going to happen. So, by getting put on some sort of unpaid leave, you can kick the can down the road. It gives you a chance to go work in another job, and while preserving your right to return to the good job. That's a possibility for some of you as well. So, but for Sylvia, again, talk to a lawyer, kick around what your options are. But for all of you, be calm and figure out dispassionately what is your best, what is important to you, and then what is your best strategy for you to achieve what's important to you, and then execute that strategy. Okay. JC again, I meant no more in terms of obligations to increase wage by adding tasks. More in terms of obligations to increase wage by adding tasks. JC, I still don't understand your question. You're gonna have to elaborate. Okay, so JC again, for instance, this is about the question about the employer asking you to do things outside of your job description. For instance, being a laborer, then want you to help train new employees or do deliveries. So JC, if you have almost no power vis-a-vis your employer, okay, you have certain rights that are protected. They can't discriminate you on various enumerated grounds under the Human Rights Code. But if you don't toe the line, they might fire you. But not only that, if they're asking, like if you're a laborer and they're asking you to train different employees, that means they like the skills and services that you provide, and they're giving you additional responsibility, and so if you do the things that they ask, maybe there are promotions and raises in it for you down the road. For in situations like that, like that's just a question of degree. You don't have any legal rights arising from it. Do you want to take a hard line and say, no, I'm not going to do that? Well, it depends. How much is your employer's goodwill towards you worth? If you're, I have laborer clients who are super in demand and get new jobs paying just as much as their old job relatively quickly. So if that's you, then maybe it doesn't matter if you lose your job or sour the well with your employer. But if it's not, then you have to assess whether or not you want the employer to sort of be less favorably disposed towards you. Let's see here. The employer fires an employee for cause, is that employee entitled to severance? So if the cause is upheld, then no. So just cause is essentially a legally justifiable way for the employer to give you zero. Now, generally, the law doesn't want you to get zero because it's a bad outcome for society when you're thrown out in the street with no money and no job. But as I was saying earlier, there are certain ways, they are less prevalent, but there are certain ways you can get to just cause, things like theft, fraud, assault, or an ongoing failure to perform in your job. So, just cause because he or she is not vaccinated. Listen, I have lots of clients who are who got fired supposedly for just cause because so the employer paid them zero because they were not vaccinated. But if you've been doing your job for almost 2 years during the pandemic, not being vaccinated, and then the employer changes its policy and says, okay, well now you have to get a vaccine, and if you don't, you get fired for just cause. Well, I mean, how could they possibly say they had a legally justifiable reason they had just cause to fire you when for the last 2 years you were able to do your job during the pandemic with PPE or social distancing or working remotely or what have you? Okay, so it just, for most of you, it's not going to be just cause. The vast majority of you, and therefore you have a right to severance, unless there's a government mandate in place that says employees in your employment sector must get a vaccine. In that case, your right to severance is extinguished. Now, whether or not a government mandate applies to you is very complicated. As I was saying at the beginning of this session here, it is very specific. There's overlapping legislation and jurisdictions across the country and in different provinces. So, if you're in that camp and you've been terminated for just cause for refusing to get a vaccine, you need to contact us, or you need to contact an employment lawyer. You can contact us at employmentlawyer.ca. help at employmentlawyer.ca, and 1-855-821-5900. It's too complicated. You need to have a lawyer assess whether or not you have a right to severance, because it's too important an evaluation. Especially if you haven't been terminated yet, but you're going to be, and you want to assess what your options are. I mean, it's just too important. So absolutely speak to a lawyer. We're pretty much out of time, as the marquee on the bottom says. I just want to see if there's any other questions I can just see if there's anything else that I can answer really quickly. JC again, can an employer get in trouble for lying and saying there's a government mandate when there is no mandate for workers? I mean, again, what is your leverage, JC? If they fire you, they fire you and you lose your job, and then you have a potential right to severance depending on your situation. I mean, if they're lying about a government mandate, is it a deliberate lie, or is it just an error because they don't know the law? If it's a deliberate lie, that can be a force multiplier to your severance, but you're still going to lose your job. So and then JC has a specific question about retaining us, and I think someone in Hope also has a question. Listen, I don't know. I can't answer those questions now. Feel free to email us at help@employmentlawyer.ca, and we'll get back to you about those firm-specific questions. But listen, we're out of time. These are great questions as always. Most of them are vaccine related. Sorry, one more thing. For your vaccine questions, if you go to covidrights.ca, I don't know if we have a graphic for it, because everything's shifting so much, and there are different mandates coming out daily in different provinces that apply to some of you. We cover all that at covidrights.ca. That might be helpful to some of you. But anyway, listen, great questions. I'm sorry I couldn't get to all of you. We have join us, I'm sure, next week. I don't know if we have a graphic, but next week we'll have more lawyers speaking for sure. And then in 2 weeks, I will be back same time on Friday to answer more of your questions. And again, I apologize for those of you I wasn't able to get to your questions. But join us again in next week, and we'll have someone answering all of your questions, employment law related, vaccine mandate related, all that stuff. Okay, great. Thanks, guys. You have a wonderful weekend.